Hi, my name is Jason Palmisano. I'm an estate planning attorney with the Private Wealth Services Group at Lowndes, Drosdick, Doster, Kantor Reed. And today we're going to talk about estate planning for the non-resident, non-U.S. citizen. Purchasing real property in the United States, if you're not a resident, not a citizen, is ideally done and planned well before you actually close on the sale of the home. It's ideal to own the piece of property in a foreign LLC, so it's not subject to U.S. estate tax. If it is already owned in your name or in your spouse's name jointly, then there's also avenues that we can help you to make that not subject to U.S. estate tax when you pass away. And so we can help you transfer that from your names to an LLC and discuss the different tax consequences. But it's good to know this stuff and get this stuff in place before you pass away, because when you do, it's going to be too late, and your surviving spouse or descendants might be shocked to realize that there's an estate tax due based on the ownership of the asset. I've worked with clients in the past where they purchased a piece of real property and the home was valued at $250,000. And they were not a resident, they were not a citizen of the United States, and the home was owned in the husband's name alone. And he passed away and he wanted to leave it to his spouse. Well, his spouse was not a resident or a citizen of the United States either. And so the exemption amount he was entitled to in the U.S. estate tax was only $60,000. So after administrative expenses and other deductions, he was looking at an estate tax based on the sole asset in the United States, this home, of about $20,000. So there's some planning that you can do beforehand to make that estate tax in the United States go away. But it's important to understand and obviously have that plan in place either before you purchase the home or before you pass away. And if you have any further questions, please visit us at lowndesleap.com.